Hello, good evening. Here is the IP Business Talk from SAPI. We are live on LinkedIn today with a very interesting personality. It's a guy who is really in the interplay between innovation and IP. And it's not just, let's say, teaching that. He is also a teacher, but he's living that on his practice, and he has a CV about that. And so I'm happy to have Heiko Seeger today with us and to talk with him. And before I hand over to him, here our recommendation: please talk with us in terms of writing questions in the chat. I'm happy to use that and to ask Heiko about these issues which coming up from you from the chat. So Heiko, thank you very much to have you here this evening. And I would like to hand over to you that you explain a little bit about your background and especially what we talked about, your philosophy about the interplay of innovation and IP.
Okay, Alexander, thank you very much for your introduction and your invitation to have me here today. That's actually a very nice experience. I mean, it's also always strange to have all the interactions by now online, but I mean, times will hopefully change again and one can also meet in person. But certainly the digital meetings will continue to make part of our future professional life. So it's actually also good opportunity. So to just give you a brief introduction about my person, you've mentioned that actually I have quite, I call it diversified curriculum. So I mean, these days I'm a European and Italian patent design attorney with Studio Torta, of which I'm also a partner. But before entering the IP field, I made different experiences. So I live in Italy, but I'm original from Germany. So I studied in Germany, also I got my graduation in physics at the University of Göttingen in Germany. I did my PhD at Göttingen too, but working at the Max Planck Institute, also going to live in Denmark for a couple of years, working at the Niels Bohr Institute. And so I got to know these academic aspects as a first aspect, which actually is not too strange for a German to graduate, to make a PhD, and then at some point to jump into the industry. But after my PhD, I continued academic research for a couple of years. And then at some point, I entered the innovation field. I started to work for a small company here in Italy, but this small company still belongs to medium and larger sized companies active here in Italy. Just to name a few: Ferrari, Tetra Pak, and then other companies, all of which are leaders in their specific fields. And the idea of this company was to operate in an open, innovative manner. So to do collaboration, to innovate together, to learn from one another. So in there, I worked for a couple of years as a technology and innovation advisor. So I accompanied the companies in the innovation processes. And this is where I actually got into contact with the patent field. And at some point, one of our contacts, he mentioned, oh, look, I can imagine yourself very well to work as a patent attorney. And this was actually for me the moment when I started to think about it. Because I mean, somehow everyone who ends up in this field has a certain trigger why you ended up. Because I've never met anyone who said I started to study and then I wanted to become a patent attorney. Actually, everyone started to study and then somehow ended up in the patent field, which actually is a very, very interesting job, because I mean you're on the forefront of innovation. So finally, I ended up in the intellectual property field, specializing in particular on patents and design. And actually, when I started to study, my aim was always to go at the university and to teach. So I always thought, okay, at some point I will be a professor and I will teach physics. And now the funny thing is that now I'm teaching, but not physics, but intellectual property rights. Because for 2 years now, I teach at a university in Switzerland, at the Fernfachschule Schweiz. And there I'm involved in teaching intellectual property to students who get involved into innovation management. So in these students, I mean, what happens or what happened in particular last year, they go into this course, innovation management, and then they end up to have to learn something about intellectual property. So they're not too happy about it, because their approach is, oh, why do I need to know it? There are the patent attorneys, the design attorneys, the trademark attorneys who have to know about it. They tell me what to do. And I think this is actually quite a wrong imagination on what you should to know. I'm convinced that when you work in the innovation field, you deal with innovation, or from the management perspective, or you're involved in the direct innovation, you also need to have some background, because it's exactly there that certainly I have a certain experience. I can tell you, I think it's better to protect this innovation in a certain way or another. But I also need your feedback, because your feedback is important in order to investigate on what is actually a business perspective. Where is your business? What is your business model? And this is where I certainly cannot tell you your business model is this, because you know your business model, you know the market, you know where there are your competitors.
At least we hope that the inventor knows it.
Or, I mean, at least in the inventor structure, there must be someone who is involved in this. And actually, I mean, for all of who are listening, there's actually also a very nice study which was made by the European Patent Office in 2017, which is called now, it's called Unlocking Untapped Value, IPO SME Case Studies on IP Strategy and IP Management. And I think that's a very interesting study, because it goes and looks into smaller and medium-sized companies and tells them how have they actually developed their IP strategy, what are the important aspects, both concerning the business and the cost aspect. Because we always, when we talk about our business or our job, we always need to keep in mind that we have to find the right equilibrium about what do we want to protect, how can we protect it, where do we want to protect it, and how much does it cost?
That's management, right? Or economics. It's the game of limited resources.
Exactly.
Otherwise, and if the resources are not limited, it's not economics.
Yes. And this is where also our job is. Not to say, okay, I'm the patent attorney, give me the stuff, and I write you the patent application, and that's it. But certainly also depending on with whom you deal. Certainly you may also need to give more advices than with others. For example, I personally work both with rather large multinational companies. Just for example, companies, they have a couple of billions of turnover, but then I also work with a little company having a turnover of a couple of million of of turnover, or the startup which has just started to work. And certainly there you really need to trigger on what can you do, how can you do it, and all these aspects. And you really need to give deep advices. While certainly bigger companies, I mean, they have their flows, and it's a little bit less.
They have processes, and we can hope that they have a certain knowledge about it. At least we have the hope. But let me ask you a question. When it comes to IP, or so to the question, this interplay of innovation and IP. So first of all, an innovation is not an invention, obviously. So we call it innovation when we have a certain success in the market with something new. And typically, the innovator has, first of all, no clue what might be the invention, what might be the market, the trade dress around the product, how to behave with a brand, how to develop a brand, which kind of trademarks are necessary to create a brand, and so on. So it's a very complex interplay. And what is your recommendation? So which IP rights should be applied, and in which cases, for a certain protection? And in addition, protection against what? Against whom? I mean, protection sounds always good, but typically IP rights are not infringed. Yeah. So statistically, it's a protection against nothing. So which IP should we apply, and which kind of protection we are looking for?
Okay, there actually we have to distinguish a little bit the different rights which we can have, because I mean we have to distinguish first of all rights which are to be registered and then rights which are not registered. For example, the last category there we have, for example, the copyright, or for example the non-registered community design. And then the other aspect are the registered IP rights, which are, for example, patents, or the registered design rights, for example, the registered community design, or also, I mean, if you look at a more complete level, also the trademark rights. So all these aspects somehow we have to consider. And then certainly we also need to distinguish a little bit on what is actually the entity of your innovation. Because, I mean, as you mentioned, innovation is a very broad term. You can have product innovation. You can also have an innovation of your business model and all these aspects. So basically, we need to identify, I mean, is your innovation, does it have a technical character? Does it rather have an aesthetical character? Or does it have both a technical and an aesthetical character? So, for example, let's assume a bottle which is a rather easy object, but also a bottle may have certain features which, for example, improve the gripping of the bottle, which again may have a role with respect to the aesthetics. And there, basically, we need to look at, I mean, we have a technical character which we can protect by means of a patent. But then the aesthetical means can, for example, be protected by design rights. And so these are, I mean, the first considerations which we need to make. And then there's actually always another aspect, which I also like to think about. And this is the marketing. Because if for example, we look at product innovation, and you start, I mean, you have your flow and you develop a new product, which potentially has eventual technical aspects which you may protect by means of a patent, which may have aesthetical aspects which protect by means of a design. But at the very end, you go onto the market. And there, the marketing, you try to generate your brand. And there we actually end up with the trademark rights, but also the brand certainly may depend on whether you have other rights like patent rights or design rights. Because I mean, it's different. If, for example, I go and have a certain product and I can say, oh, patent pending or design right, and so on and so forth, I can certainly give to the consumer. If, for example, we address the business to consumer market, we can show them, okay, this product has a certain value because we have a patent right, we have a design right. And
But
I
does
think
the customer care about such a value, or does customers care about benefits?
no, I
mean,
think
a value is an objective thing, yeah, in terms of we show that we are inventive, okay? We have a new technology. But at least from the textbook knowledge, we say customers don't care about your technology. Customers cares about their benefits. I mean, isn't it a smart move to say, let's focus on the customer benefits? They should be protected, and maybe not so much the technology per se.
no, I personally, what I think, I mean, it's true that the customer has a certain benefit. But if I'm able, I mean, I also have to have the right marketing strategy. But if I go and say, I mean, I have a certain technology, I mean, the feedback which I've obtained from some of my clients is, oh, I've spoken with my customers, and I said that I've applied for a patent application. I've applied for a design right. They say, oh, wow, that's a good thing. I think that's important. Also, if you look, I mean, I don't want to make now any names. But if you look at some car manufacturers, I mean, or their brand is based on the consideration of having a certain technology. And
yeah. Is that so, or is it a brand reputation? I mean, when I look at BMW, or so, let's say BMW is exchanging engines with Renault, and they put it in the Mini. Why? Because Mini buyers don't care about the engine. It's not technology. It's because it's a Mini.
Yes, but then you also have the aspect. If, for example, certain companies, if now, I mean, recently I read still a lot of German newspapers. So to keep me updated also with Germany, even though living in Italy, and there was actually an article in the Spiegel about Volkswagen.
Yes.
And the different strategy which they adopt about the different brands, because if you look at Volkswagen, it's a big mess somehow.
Yeah,
I mean, they have Skoda, and then they have Porsche, they have Audi, but all these have different brands, different standings. And if now we've started to also give some names. If you look at Audi, they try to say that they are the leaders in the Volkswagen multinational company with regard to technical aspects. So they have to be the first. And certainly then there's also the protection point behind it. But certainly you somehow need to transport it.
Yeah, got you. Mm-hmm.
Because
so Martin, yeah, I got you. Martin Wilming is raising an interesting point here, because I said that only a few IP rights are infringed. Okay, so and the question is why, yeah. And he says there are two options at least for the right holder. One is that IP rights are not infringed because they simply don't forbid something reasonable in terms of others solve the problem anyhow different, and insofar it's worthless having them. And another perspective, so to speak, the opposite is no. A fact is that the others respect the rights, they are informed about the rights, but they don't want to infringe, and insofar they behave rational in bypassing the rights in terms of accepting that. Both perspectives are very interesting. What is your expectation, or also your experience? I mean, I have quite often exactly that discussion. Right today, I had a machine manufacturer discussion this morning. What should we do when there are so many digital patents out there already? So we have around 5G, we have, I don't know, 150,000 use cases. They are using 5G, even when 5G is not existing in anywhere at the moment, but they are protected. And they say, how can we bypass that? So the original thought is, we don't want to infringe, we want to accept, and so we bypass. What is your experience with the different size of companies? Is the acceptance of IP different there?
Okay, basically my experience is that most of my clients, they say that in their field, there's actually the situation of the second case. They accept the IP rights of the others. So they, because they basically, so I mean, that's now maybe also a bias in the fields I work in. I don't know, but I think in general, companies, they don't want to litigate. Because litigation is quite costly. You never know what will happen. You never know what will happen. You have to spend a lot of money. So they actually try to respect the rights of the others. And
okay.
This is what.
I mean, that's my experience too. So I typically don't have companies with which I'm working, which says, okay, I give a piece of shit of IP rights, I don't care. No, they are afraid of that when they get the knowledge that they get noticed what happens out there. They simply ignored it, but that's something different. Yeah, ignoring is not that I know it and intentionally I infringe. That's something different. I mean, you mentioned you are located right now in Bologna, right? And
yes, I work at the Bologna office. Yes.
Yeah. So you have in Milano. You have an office. I mean, Northern Italy is very famous for their designers and for the furnished products and clothes and everything which has to do with design. So it's I mean it's the hot spot of the design industry. And so what would you say when I have an innovation, and this innovation, let's stay in a B2C environment, and when I come from a design perspective, what would you say? What should a business consider in terms of IP protection then?
No, I mean, if you talk about the design aspects, the ethical characters, I mean, then we immediately end up thinking about design rights. So, which I've mentioned at the beginning, we have the non-registered design, for example, the non-registered community design, which can give us protection for 3 years, which actually is an interesting tool, for example, for the fashion industry. Because if you look into the fashion industry, they don't file too many design rights because it's a very quick industry. I mean, now they're thinking about. I mean, they're planning for the new edition of autumn and winter, where everything is prepared, and they're actually already having new models for spring and summer next year. So, but then. Also, there are certain models which are longer lasting, which you do not want to just keep for one season, but you want to keep it for a couple of seasons. Then it becomes more interesting to go to register design rights. And this is in particular also, I mean, if you look at other design objects, I mean, lamps, armchairs, and
Suitcases.
tables, suitcases. Certainly, the lifetime, the life cycle of the product when you want to market it is much longer. So there, it really becomes interesting to think about registered community designs. And that's actually interesting that Italy, in this regard, is, I think, the 4th top filer of community designs. I think there are, I mean, if you look at the statistics, Italy ranges at place 4, I think, more or less. Why this is different with patents. For example, if you look at the filings of European patent applications, Italy is not in the top 5. While with community designs filing, it is in the middle. And there
it makes sense in respect to the main industry and where the money comes from, right?
Yes, but also it's also a cultural aspect, I think.
Okay, can you explain that?
No, for example, I personally, I mean, I come, as I mentioned, I'm a German. So, and often I speak also with other German patent attorneys and we discuss. And also, if you look at the numbers of law firms in Germany, I mean, just look at the numbers of the European qualification examination. Look at how many German patent attorneys there are, which has different reasons, but also another reason is that German companies, they are more open to invest also into patent rights. While in Italy, there's still, from my point of view, a lot of room to improvement. For example, I know from one of my clients, now they started to be more organized for many years now. But in the past, it happened that they went to a trade fair, they presented a new solution, and 3 years later, they were blocked with this solution because the competitor realized that there was an important part which were necessary to make it work, and they patented this particular aspect. So because there's also an aspect which you need to consider. IP rights, in particular the ones which you registered, come along with a cost. And then you can see this cost as an asset, or you can see it as a pure cost which needs to be reduced to a minimum. And I think here in Italy, this is my impression, but I think many agree. I have the same impression. There's still room to improvement with regard to these aspects. I've just had a client. They didn't want.
No, proceed.
No, they didn't want to invest too much into a patent right. Someone else patented it, and now they lose a couple of million every year. So
I mean, that's how the things go. That sometimes you need that bad experience. So in terms of learning it on the hard way, really. But I think what the EPO is doing and what we are doing at the IP Business Academy, we write that case studies, we promote that case studies, that companies don't have to learn it in that hard way, to show how IP can really work. And that leads to what you said as the introduction statement. That it is necessary that the innovation guys understand IP. I would even say the product manager, marketing guys, they have to understand IP. Otherwise, they cannot understand why it is so important for them. Because at the end, the patent department has not really a benefit from the existence of IP. I mean, they are the IP experts, but from a property rights theory, they don't benefit from it. The benefit is for the marketing guys or for product management, for business developer who are able to create business on exclusivity. So they are our targets in terms of they should learn it. We have to explain it. and not just the IP community, because the IP community knows that it is important, but this is not helpful, so to speak, to change the situation as you explained.
Yes. No, I mean, this is why also, I mean, at the courses which I teach there in Switzerland, I also try to tell the students that it's important, also that it's important that they know it.
Yeah.
Both
Yeah.
regarding the business perspective, also other easier aspects. Like, I mean, how often does it happen to you that you go somewhere, in particular to companies which have less experience with patent rights, and they said, oh, we had a great success at the last fair with this new product, we would like to patent it.
Yeah.
And then you say, okay, that's not the easiest way now.
Thank you very much. I mean, but Maria in the chat, right? I like that pretty much. That this cultural issue, because I mean that's what we are doing here on the SAPI IP Business Academy and on these talks, that we go in different countries and regions really. And she says, and last week we were in Latin America, and Marina says that it is really a cultural issue. She talks about Brazil, and that is there really a problem to establish an understanding of IP in general. Yeah, I mean, something what we saw in China, that they switched totally from a regime where they said, I give a piece of shit for IP, I don't care. Yeah, and they switched completely the whole country in terms of, hey, IP is the greatest thing ever, and we invest a hell of money in it. So yeah, it has something to do with communication and these best practice. And to learn it from each other. I mean, that's why what we do at the IP Business Academy, to help especially companies to learn. I mean, something in addition to these different aspects. What would you say? What should I take into consideration when I want to protect an innovation? So let us assume protection against imitation. Let us further assume that there are potential imitators out there, whatever. I mean, I prefer the wording of creating exclusivity, because this is what you get exclusivity. The question is, because protection is always means that imitation, and that's something different. Yeah, but okay, whatever, let us assume we have an innovation, we want to protect it. What would you say? Is there a checklist, a guideline, a general recommendation, which aspects we take into consideration here?
Okay, I personally think, I mean, this is what I also always tell my students, is that there are different aspects to consider. And the first aspect is the one of the actual innovation. What is the nature of my innovation? Is it a technical innovation, or is it a rather aesthetical innovation, or is it both? So this is the first aspect, I think, which one needs to consider. Then certainly, I also need to evaluate on what is actually the strength of my innovation. I mean, is it a small improvement? Is it an important improvement? Can it become a game changer? So, and then I need to think about the business aspects, because I want to have exclusivity. But I mean, in order, I mean, certainly to have a certain return of investment. And there I certainly need to look at, I mean, what is actually the market I'm interested in? Where do I have a market? What might be my future plans to grow the market, or my business model? I mean, I can have a certain business model that I say I don't care about, for example, licenses. But I can also have a business model where I say, okay, today I don't have licenses, but I plan to license my inventions starting from 5 years. I need to know very well also my competitors. I need to know who are my competitors in the markets I'm interested in? Where do they have their place of business? Where do they produce? Eventually, if they have third parties producing somewhere abroad, where do they import from? Where do they import the materials, or I mean these aspects? So I think these are different aspects which I need to consider when I want to define a certain patent strategy or a protection strategy. And then certainly there maybe the patents are a little bit easier from a certain point of view. If you think about, I want to have a world, I mean, to extend my protection to different countries, but the design rights there, it becomes a little bit more tricky. Because, I mean, there's a little bit more harmonization with respect to the patent rights than with respect to the design rights. Also, for example, if you look at community designs, which I always call, it's a very liberal legal framework. For example, here, if file a community design, I have a lot of freedom on how to define the protection. For example, if you think about an earring, which is a three-dimensional object, as a community design, I can represent it by a two-dimensional single view, while this is not possible in other countries. I can here, with respect to community design, I can use dashed lines or dotted lines in order to disclaim parts, which I cannot do everywhere. So there, actually, when I start to think about design rights, I actually, from the very beginning, I need to define very well where I want to go. Because otherwise...
So, just something which puzzling me a little bit. So you mentioned the business model, and I guess that is really a trigger here. Yes, I agree. Of course, we have to think about countries and these aspects. But my understanding and my experience with inventors is that they are not that clear when we have a startup, for example, about the business model. So let us assume, I mean, all what you said is totally correct when we talk about a differentiation strategy. And that's the working horse, of course, for most of the companies running a differentiation strategy. But let us assume they want to go for a monopoly in a box, so an ingredient branding. Yeah, so I have something which I offer to a third party, and this third party is then selling it. So like Gore-Tex or Shimano or these typical examples, or Intel. I mean, that's a very smart way to do it. But then, first of all, the brand and the associated trademarks are the cornerstone of working with it, and not so far design rights, and not so important are the patents, for example. And so, I mean, without an understanding of the business model, I think you agree, it is extremely hard to define a meaningful strategy for working with IP. I mean, then everything is right or wrong at the same time.
No, that's true. You need to know what you want to do. You need to know on how do I want to make the money.
Yeah, I mean, and that's for me the most important point, because I have it's not so seldom that people come to me and say, Alex, I need an IP strategy. I say, yeah, okay. And what is your business model? What is your business strategy? Yeah, I don't know. But first of all, I need an IP strategy because I guess I have an invention. And but the invention doesn't explain which kind of IP we will need later on to promote your business model. Yeah, and this leads us exactly to what you said as an introduction statement. When inventors, innovation management, when they don't understand this interplay, for example, of exclusivity based on IP with business models, they simply don't understand why we are asking that. They just think a patent is a patent and one fits it all, and so don't ask me. I mean, it's so important what you're doing there, to explain really this interplay. I like that very much. So you mentioned in our discussion before we started here live on LinkedIn, and diversified IP strategy. Can you explain us a little bit what you mean with that?
No, I mean, when I talk about the diversified patent strategy, I immediately, what I mean is that when you think about your IP strategy, think about all the possibilities you may have. So, which is, I mean, right, the past minutes, we've mainly focused on the registered IP rights, like patents, designs, we talked about it, but there's also a very important aspect, which is the copyright. So, and I think this is a right which one always should keep into mind, because there have been some important decisions by the European Court of Justice, which have given certain interpretations about what can you do with a copyright, also with regard, for example, to industrial designs. For example, in a country like Italy, the case law actually said that, okay, copyright, basically, you cannot apply copyright to the protection of an industrial design. This was, I mean, for many years, the basic idea. Then there was the development to develop certain criteria on when an industrial design may also obtain protection by a copyright. And these criteria actually, with the latest decisions by the European Court of Justice, have a little bit lowered. So I obtain a new possibility to play. I get a further card which I can always consider in order to protect myself. And there was also
what I pretty much like what you say is, because quite often, you know, I don't want to bash patent attorneys. Yeah, I don't want to get wrong, but quite often when you talk with a patent attorney, it's a little bit like, because I have a hammer, every problem is a nail. Yeah, and so file your patent. Where's the question? I mean, what you say is, when we have this diversified IP strategy, it means just play your cards and think wisely about all these options which we have, in addition to cost constraints, to future flexibility. So there are really many aspects which should take into account to come up with an IP strategy. And yeah, just having a patent is not a value per se. It's first of all, it costs money. And what you say is that we should really think in IP, even maybe not just in IP rights, in IP in general, so first mover advantage and others, to make it smart and to fit it to the situation of the company.
Yes, and you should be creative. You should, for example, certainly if you are a patent attorney and most of your time you invest on patents, you start not to think about the other aspects. You get loose of track. Okay, there's design, there's trademarks, there's copyright.
Yeah, you become a kind of patent production machine.
and there certainly you always need to keep in mind that there are other rights. There are other patent, I mean, IP rights, not only patents. There's design. I mean, I've given the example of a bottle. There are tripping means which may help. They have a certain design which you may protect by means of a patent, by means of design right.
Yeah. I mean, sometimes even the patent departments, so to speak, in companies are the problem, or are the bottleneck, that they say, we have KPIs, we have to produce patents. And so it's not about finding the best IP strategy solution. It's about, we need patents, we need inventions. Otherwise, our CTO don't think we are innovative enough. Okay, so I have to look at the clock, and we are more or less at the end. Heiko, thank you very much for that extremely interesting discussion. I mean, that's really talking with an IP guy. It's fun. It's great. Thank you for your insights about the Italian situation. We have in the chat many aspects which I was not able to talk with you about, the question of infringement cases and time consumption in Italy, and I would like to make a deep dive also into the question of IP. Design rights on the one hand and copyrights on the other hand. I think that's extremely interesting. So I guess we will see each other again here in that format, and we have to discuss that further. So thank you very much for your time and your insights, and see you next time. And to the audience, thank you for discussing that. And Pedro, I'm absolutely with you. Yes, a strategy has to fit like a dress. That's wonderful. That's a good picture. So thank you, goodbye, and good evening.
Thank you very much. Bye-bye.